Hey folks, good morning. My name is Greg McLawsen. I am the Affidavit of Support lawyer. I represent green card holders in federal lawsuits to enforce the US CIS Form I-864 Affidavit of Support. And this week, I'm going to try to do a series of videos kind of catching up with some various decisions that have issued around the country concerning the Affidavit of Support. I try to keep abreast of these whenever they're issued. And it's been a while since I did some videos on some of these new pieces of case law, so I thought I would go through them. The first case I want to talk about is Dandan v. Dandan, which came out of a divorce trial in the state of Michigan. It's that time of the year where the colds are going to start coming in, so I think I may have the first one of the season. The affidavit of support, as I've spoken about thousands of times, can potentially be enforced either in federal court or in divorce litigation. Now, almost all of the cases that I do are in the federal arena. That's for a variety of reasons. Basically, I think my clients get better results in federal court. The affidavit of support arises under federal law. Typically, it is a cleaner issue to bring up in federal court. But lots and lots of people all around the country litigate the affidavit of support in divorce cases, and this is one of those cases. The affidavit of support, again, is required in all family-sponsored cases. Most of the litigation around the country comes out of marriage-sponsored cases. So the affidavit is required when you have a parental petitioner or a sibling petitioner, child petitioner. But where we see this contract getting enforced most often is by ex-spouses. And very often it comes up, as in this Dandan litigation, in the context of a divorce. In this case, we had a US citizen who got married to a individual from Israel in 2015. Brought them to the United States, and basically in around 2018, they were completing the immigration process. Quick side note, when you get a green card through a marriage in the United States, and that marriage has been around for less than 2 years, so if your marriage hasn't hit the 2-year anniversary yet, and you get your green card, you get something called conditional residency status. That's good for 2 years, and then after the end of the 2-year period, you have to go back and show them that the marriage was legitimate and transition to a permanent residency status that can be renewed indefinitely. So in this case, because of how long this couple had been married, in 2018, the foreign national got a 2-year residency card. Shortly after that, it sounds like the marriage hit some bumpy period, and the couple ended up getting divorced. Let me take a quick pause here to say that I get how this feels from the perspective of a US citizen petitioner. This person met somebody from abroad, brought them to the United States, secured residency for them, and then as soon as they get through that residency process, things don't work out, the couple separates. If you're the US citizen petitioner, I understand that you are going to be second guessing whether that foreign national had ulterior motives that they were pursuing, and maybe they never loved you, and maybe they were just marrying you for a green card. This argument, and that is the argument that in this case it's referred to as the plaintiff, the US citizen, that's the argument that the plaintiff made in Dandan. I get that that comes from a sincere place, and the US citizen petitioner probably did feel wronged. So let's look at what the court did here in Dandan. At the trial level, so at the divorce court, issues of fraud, and this goes across the United States in different courts, different states, allegations of fraud are always held to a very high standard of proof because it's very easy to get into he said, she said arguments about, in this case, somebody's intention in a marriage. So courts apply something called a clear, cogent, and convincing standard of proof in these cases. What that basically means is that courts are skeptical about allegations of fraud, and they require them to be proven to a very high standard. And the trial court in this level, in this case, in the Dandan litigation, found that the US citizen did not meet that level of proof. The trial court said, look, this is a classic situation of he said versus she said. The US citizen petitioner says, hey, this person left me right after I got the green card for them. This doesn't look legitimate. And the foreign national testifies, it was a real marriage. We were married for, I believe it was 7 years at the point that this actually gets litigated. It was a real marriage. It just didn't work out. And the trial court kind of throws up their hands and says, well, it's one person's story versus the other person's story. In that scenario, I'm not going to find fraud because there's no real evidence that there was bad intention here. So the US citizen loses at the trial level. The trial level enforces the affidavit of support, and it goes up on appeal. Now, there are kind of two basic different ways that a court of appeals could deal with this issue. The court of appeals could look at it from a factual perspective and say, okay, there was a trial in the divorce litigation over this issue of fraud. And does the evidence support the trial court's finding that fraud didn't exist? That's kind of a fact-intensive way of looking at the issue. The other way, and this is the way that most federal courts would look at this fraud allegation, is to say, let's imagine that the US citizen petitioner does have evidence of fraud. Even if they can demonstrate that with convincing evidence, again, to that very high standard that's required for fraud, even if they can do that, does that constitute a valid defense to liability under the affidavit of support? In the federal context, and that's where I represent my clients, is in federal district court, we have argued all over the country, from Maryland to California, Washington State, everywhere, that allegations of fraud categorically, meaning under all circumstances, simply are not a defense to liability under the affidavit of support. And the reason for that is the way the statute is written. In 1996, when Congress was creating the affidavit of support, Congress said, if you bring a family member to the United States, you must sign the affidavit of support promising to provide financial support for them. That obligation, it starts as soon as they become a resident of the United States, and it continues. And then certain circumstances are listed, primarily when the person becomes a citizen or has 40 quarters of work. So what we have argued consistently in federal court is, once that foreign national becomes a resident, liability under the affidavit of support is triggered, and the only circumstances that alleviate a US citizen from that responsibility are the narrow circumstances defined by federal law. So in the context of fraud, it doesn't matter, Judge, any set of facts that the US citizen can try to produce. Allegations of fraud, just under all circumstances, are not a defense to liability from a legal perspective, and so you don't even reach the factual issue. That second approach is basically what the Court of Appeals did in this Dandan litigation. The court starts by talking about the high standard that fraud issues are always held to in federal court. But then the Dandan court kind of changes gear, and it cites to two different cases that my law firm litigated in federal district court in Ohio: the Mao v. Bright litigation and the Ibrahim v. Abdel Hoke litigation. These are both the district court decisions, but they are published, meaning they're given some sort of authoritative weight by other courts. Both the Mao litigation and the Ibrahim litigation got very detailed, well-reasoned decisions by the federal judges we were litigating in front of. And what the Dandan court does is essentially follow that reasoning that I was outlining a moment ago. It follows Ibrahim and Mao, both of which say, when it comes to an affidavit sponsor's liability, it is limited by the federal statute. And if we want to look at when liability starts and when it ends, the only thing that we are going to look to are those terminating events that are defined by federal law. And so it doesn't matter whether that sponsor had proof that the foreign national had bad intentions going into the marriage. The risk allocation mechanism of the affidavit is intended to put on the shoulders of the sponsor the responsibility of providing a financial safety net for the immigrant. So as soon as that person gets their residency status, the US citizen is on the hook. And the only thing that alleviates that responsibility is once the terminating events are hit. So becoming a citizen or departing the United States and losing residency, getting 40 quarters of work, those things that are defined by federal law, that is what gets an affidavit of support sponsor off the hook. But we are not going to let that person off the hook by going into a divorce trial and arguing about the party's intentions going into a marriage, because it just doesn't matter under federal law. So a couple things to say about this. This Dandan decision is what's called a per curiam decision. It means by the court. When you have a court of appeals that is dealing with a important decision, it's going to be authored almost always by a specific judge, or in the case of the Supreme Court, a justice. When a court does a per curiam decision, it can mean a variety of things, but what it almost certainly means in this case, especially because the decision was made unpublished, meaning it's not given formal precedential value by this Court of Appeals. What this almost certainly signals from the Court of Appeals is that they thought this was an easy case. When it went up on appeal, the Court of Appeals looked at this and wrote a very nice, well-reasoned decision, but they didn't think this was a very complicated issue. And that is notable to me because from an intuitive standpoint, I think a lot of people would identify with this US citizen sponsor. I think a lot of people would be inclined to say, well, look, if this person married somebody from another country and that person did have bad intentions, that's something that ought to alleviate them from liability under the sponsorship contract. But we are now 25, 30, 40 years into the Affidavit of Support being litigated around different courts in the country. There is a almost consensus view, meaning all judges are agreeing on this issue, that fraud is not a defense to liability. So this really jumps out to me that when the Court of Appeals in Michigan addresses this issue, which probably in my mind would have been perceived as a pretty novel and important issue not very long ago. This came out in May of 2025. Now the Court of Appeals says, yeah, this is kind of an easy one. And we look around, we don't have to look very far. We just take a take a quick look at a couple decisions. Again, the ones that were litigated by my law firm in Ohio, the Ibrahim case and the Malby Bright litigation. And they say, look, federal courts are pretty clear on this. And allegations of fraud are not a defense to liability. So, they wash their hands of the issue and affirm the trial court. That's pretty notable to me. One additional thing that the Court of Appeals goes on to address is the issue of whether annulment would be a defense to liability under the Affidavit of Support. In my mind, this is really just a variation on the same fraud argument. But the plaintiff, the U.S. citizen in this case, beg your pardon, kind of put a twist on the fraud argument and said, well, look, what if I could show that the marriage ought to be annulled because of fraud or bad intentions on the part of the foreign national? Would that alleviate me of liability under the affidavit? And here's what the Court of Appeals said. Although marriages may be annulled on the basis of fraud, there are only 5 ways that the signer of an I-864 Affidavit of Support may avoid the attendant responsibilities and obligations. Because marriage status does not factor into any of those 5 bases, changing the divorce to an annulment would not provide plaintiff, the U.S. citizen, with the relief that she is seeking. So that is correct. Even if the United States citizen were to successfully litigate an annulment and annul their marriage to the foreign national, the Court of Appeals in Michigan says correctly that would not change liability under the Affidavit of Support. Why? Because what triggers liability? It's when the foreign national gets U.S. residency. Once that residency is triggered, it doesn't matter if the marriage is annulled. It doesn't matter if the person could be deported. As long as they are here in the United States, the sponsor promised to be a financial support for that foreign national, and they are on the hook. They do not get out from under that Affidavit of Support until one of the 5 terminating events has occurred. So again, that's a fairly well-established proposition in federal court, but I think it's notable that a Court of Appeals in Michigan also saw that as a sufficiently black and white issue that it did not even merit a published decision. So what Dandan stands for, in my mind, is more support for this groundswell opinion that fraud is not a defense to liability in federal or state court to liability under the Affidavit of Support. And I think what's most striking to me about the Dandan case is the fact that it's unpublished, the fact that it's per curiam, indicates to me that the judges deciding this issue understood, A, they got the law right. They agreed with federal courts that say this isn't a defense. But they also understood that this is such a well-established proposition at this point that they didn't need to make a big deal out of it. I've argued this issue, twice in the past 2 weeks in different federal courts. So this is definitely an issue that does still come up. But I think it's really notable that the Court of Appeals in Michigan saw it as a black and white issue and said, hey, nobody needs a published decision from us on this issue because it's pretty black and white. Hope that's helpful. I'm going to try to go through the case law and pull out a few more interesting decisions later this week. If you have questions about the Dandan litigation or other questions about the Affidavit of Support, feel free to jump into the comments. I'm pretty quick about answering general questions about the Affidavit of Support. If you'd like an individualized case assessment, feel free to reach out to me at soundimmigration.com. I represent claimants in federal court enforcing rights under the Affidavit of Support. Hope that's helpful, everyone, and have a good week. Take care.